Now back to the show. This is AM 650's The Law Show.
Welcome back to the program. Red Robinson and the Diner coming up in a very few minutes. But now we have the very last segment of our guests, David Hobbs and Ian Giroday from the Vancouver estate litigation firm Hobbs Giroday on the Law Show here. And gentlemen, we've talked about this particular aspect or this particular item in the past. And since we're talking about competency or lack thereof on the program today, I wanted to ask you about the public guardian and trustee, because we've alluded to this officer in the past. How relevant is he or she in the conversation regarding competency?
Well, there are people in life who have no one to look to. They may have no children. They may, they're on their own, so to speak, and we have the Office of Public Guardian and Trustee to become a trustee for such a person and their estate. Public Guardian and Trustee also deals with infants. Of course, infants are we in law we call them disabled, i.e. they're not able to make contracts and look after their own affairs.
Sure,
and so the
right.
Public Guardian and Trustee looks after the interest of infants so that they're not taken advantage of by people who might settle a lawsuit for an infant or some other issue of that where the infant has rights or money. So they're an office. They're an entity under a statute. They have a person who is the speaking appointee, if you will, of the office, like the board of directors of a company sort of concept.
Right.
And they have deputies, and they're brought in sometimes when there's a concern in a family dispute that a parent is incompetent. Sometimes they'll go and interview the parent to determine whether or not they do think there's a question of competency.
Right.
And will step in and intervene if that person's being taken advantage of by someone.
Interesting stuff. Ian, I'm kind of bouncing around a little bit here, but we've only got a few minutes left, and I wanted to cover some bases. Gifts. In a will, immediate family members usually receive a portion of the estate, be it real estate or money or whatever, but sometimes the next-door neighbor or the old fishing buddy gets a gift. If the creditors are always the first to be paid, where do people who are on the gift list end up versus people in the immediate family?
Usually a person, an old fishing buddy or next door neighbor, usually they get a specific gift.
Yes. Yeah.
And so, if the creditors are paid out and say the specific gift is the old fishing boat, presumably that didn't have to be sold to meet the debts.
Right.
If it didn't, then the gift passes because it's there to be given. Obviously, if the assets of the estate do not aren't sufficient to pay the creditors and everything has to be liquidated, then the gift may not come to fruition. But there's no as between gifts, there's really no sort of hierarchy. There's specific gifts, and then there's the residue. Now the specific gifts may and the debts may exhaust the estate such that there is no residue at the end of the day.
Right.
But generally speaking, there's no sort of priorities as between specific gifts.
Okay, David. When people come to Hobbs Giroday, and as Ian and you have both identified in the program today, they're dissatisfied. They feel that somehow or another their position in the will is not right for any number of reasons, and they go on. When these people call you up, the first meeting is always free. It's complimentary. They want to find out about you and you about them. What should people have at their fingertips when they go on the website or call you up? What sort of information do you want right up front to help you and Ian and your colleagues assess whether or not this is a case of interest to Hobbs Giroday?
Well, we usually have a conversation with people, then we have a meeting. Quite often in preparation for the meeting, we'll ask them to prepare a chronology, a narrative. We'll ask them to provide us with all the names of all the actors in this narrative that have a role to play, be it positive or negative, i.e. who are all the interested players in this story. And quite often we'll want to know about the estate. Is this a $10,000 estate? Is it a $2 million estate? What are the assets? What
Right.
are we talking about? And any documents they may have that are directly bearing on point, whether it be a copy of a will or some other piece of information that relates to it may be a note from their parent saying, I just want you to, Johnny, to know that I'm leaving you something in my will that they wrote out on a card one day or something. But that information is gathered. We have a meeting. Usually, well, invariably, there's no obligation at our meetings. We're there to meet them, the potential client, to hear about their problem. They're there to meet us. And we're all sitting there looking at each other, contemplating whether we're going to take a project on, whether we're going to have a relationship.
Right.
We formalize the relationship in writing, and the lawyers call that a retainer letter.
Right. And so this is where the discussion of fees, Ian, for example, would occur. If we're going to take your case, then this is what you should expect by way of costs.
Right. Our practice is to be upfront about the business side of things. We will usually spend a good deal of time on sort of the issues, the merits, the concerns, but in our first meeting we'll invariably turn to sort of the business side of things, and
right.
Because potential clients need to understand that legal services cost money.
Sure.
And we explain to them the potential ways we might be prepared to work on their case. It might be an hourly rate. It might be a flat fee to achieve a certain get to a certain point. And in some cases, we may be looking at a contingency fee agreement.
Sure. David, you've alluded to this a couple of times in the conversation, and in our last minute, this is all very calmly being discussed by two eloquent pros in studio with me today, but this is a pretty emotional subject, and a lot of people come to your offices, and they are just wrung right out, aren't they?
Yeah, what I've learned, I think some people try to ignore emotions and sort of say to people, well, emotions don't matter and so on, and let's just deal with the hard facts. But the reality is emotions do matter, and they need to be recognized and respected and put in their proper place in the discussion. And then there's what I would call the business side or the
right.
legal side or the practical side. And I always try to keep them as two connected but separate discussions, recognizing both, because emotions matter, and we all behave in ways that maybe sometimes we wish we didn't because of our emotions and regret later and so on. It's something that's like a wild horse. It has to be controlled as best as possible in all the circumstances.
That's challenging work, I'm sure. David Hobbs, Ian Giroday, thank you so much for being with us again today. Great to see you both again on The Law Show.
Thanks, Sterling. Good to be here.
Thanks, Sterling.
Red Robinson coming up next. Have a great day.